And I would still ask for a show cause just based on what he represents to me regarding his work and housing status.
He apparently has a phone.
That is true.
All right. Defendant has failed to appear and failed to pay. Bench warrant's gonna issue. Given his housing situation, I will make them low monetary bonds, though.
Thank you.
1,000, 10% on each. All right, let's try this for a third time. State of Michigan versus Tyler Hagedorn, 25S00113.
What's with people?
Matthew Mansour on behalf of Mr. Hagedorn. Tyler, you know what to do.
Thank you. Mr. Mansour?
Your Honor, I have received Mr. Hagedorn's father's number. The best I can do is reach out to him and try to provide proofs that they are willing to accept his application, because I believe he's on a list. He said his name is on the list. It's called the TPT for the local 900 list at Ford. That's the best I can do to try to provide the court documentation that he does have a job lined up. Outside of that, Your Honor, he just wants this court to consider, please just giving him a chance to test immediately. Like if we give him a personal recognizance bond, he will test upon release for drugs and alcohol. I got him to accept if the court would test him once a week for drugs and alcohol. If there's any violation, then immediate bond denied, warrant, and then check into inpatient treatment program. He's also willing to, if the court's worried about him absconding, be put on a GPS home confinement. Right now, I have an address. It's at a hotel, and he can stay at that hotel for at least a month. With, I believe, his sister staying there as well. I have the address as well. That's all we can request right now, Your Honor.
Thank you. Ms. West, do you want an opportunity to say anything more, or are we all set?
Judge, I just want to put on the record that I object to that request. He's failed to even check in at community corrections. He's failed to drug test even after you asked him to do it within 24 hours. He still failed to do that. And you told him if he didn't go, you'd put him in jail. I think that defendant's willing to say anything at this point just to get out of custody. And I don't believe that he would follow this court's order at all. Thank you, Judge.
Thank you. I'm gonna put this over for, like I said, to Thursday to see what proofs we have of him having any job, or if there's opportunity for him to fill out an application. I will allow him to be released to a treatment. I'll consider on Thursday, after whatever proofs we have, whether or not he can be released on a tether without going into a treatment program.
Thank you, Your Honor.
I'll see you on Thursday at 9, sir. State of Michigan versus Ozell Hyman, case number 25 FB 1007.
Hey, what's with people?
You can go around that way, sir, if you want.
What's your name, sir? What's your name, sir?
Shaq Khan.
Roll call the matter of the state of Michigan versus Shaq Khan, case number 25S00039.
Ashley Moten on behalf of Mr. Khan. State your name, sir.
Shaq Khan on the record.
Thank you. All right, we're here for a bench warrant. A bench warrant was issued by me in this case because Mr. Khan failed to test at all on July 1st, 2025. And he had police contact of some sort.
Yes, regarding the police contact, he was pulled over for a traffic violation, no proof of insurance and expired tags. He was driving someone else's car, and the insurance has been updated, and the tags there's a appointment scheduled for tomorrow for the tags to be renewed. And regarding the missed test and the one late test that was negative, he honestly does not recall. He does have some medical issues that causes memory loss. He does not know why or how he missed those tests because he has been working to be compliant with that. We are requesting that he receives a personal bond today. He has no issues moving forward complying with his previous conditions.
Mhm.
May I ask if I could honestly get an alcohol tether?
Instead of the sober link.
Yes.
Okay, one moment.
All right, let's talk about that. This hearing with Magistrate Hillary Braley had all the hallmarks of her steady, measured approach, firm where needed, but always willing to listen. The case in focus was State of Michigan v. Shaq Khan, which came up on a bench warrant after Khan failed to test on July 1st and had a run-in with police over a traffic matter. The facts were straightforward. The traffic stop was for no proof of insurance and expired tags. But his attorney, Ashley Moten, clarified that the insurance is now valid and the tags are scheduled for renewal the very next day. The more concerning part was the missed test and a prior late test, though that late one came back negative. Khan, for his part, didn't come in with excuses. He admitted he didn't know how he missed it, citing medical issues that cause memory lapses. That's not something you hear every day, but it's also not unheard of in court. The key was whether the judge believed it was a lapse of memory or a lapse of compliance. Moten made the pitch for a personal bond, emphasizing that her client had been making genuine efforts to comply overall, and even requested a swap from the current SoberLink system to an alcohol tether. It was an interesting tactical move asking to change the monitoring method rather than just dropping it, which may have helped position Khan as someone who's not trying to avoid scrutiny, just looking for a setup he can handle more consistently. Magistrate Braley, as usual, was patient in hearing the full explanation, but she wasn't about to gloss over the fact that the court's instructions had been clear and the EMIS test was a real violation. Her questions kept the conversation grounded in facts: what happened, what's fixed, and what will change going forward. The courtroom atmosphere here was calm and professional, without the spikes of tension you sometimes get in bond violation hearings. Even when discussing the bench warrant, there wasn't any visible hostility, just a shared understanding that compliance is non-negotiable if you want to stay out on bond. Khan came across as earnest, even a bit subdued, which worked in his favor. There was no argumentative back and forth, and Moten's advocacy was steady, focusing on the fixes already in motion rather than getting bogged down in why things went wrong. The bigger takeaway is how Braley runs her courtroom. She listens first, weighs the facts, and looks for a way to balance accountability with the practical realities of someone's life. She didn't dismiss the seriousness of a missed test, but she also didn't treat it as an irredeemable failure. This kind of approach keeps the process fair without losing sight of public safety. And for defendants like Khan, that means a chance to correct course instead of just getting locked into a downward spiral of bond revocations and new warrants. It's not the splashiest hearing, but it's the kind that shows how much of courtroom work is about problem solving rather than punishing. Everyone left the room knowing exactly what the expectations were going forward, and with a plan that addressed both compliance and the defendant's stated limitations. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.